When it's said that there's a hierarchy of equality in European law, I think there are at least three different dimensions to that notion. One is the effectiveness of the law. The second is the scope of the law, what areas of life, what fields of social life it covers. And the third is the number of exceptions that there might be to the prohibition against discrimination. So grounds on which employers or the state can justify discriminating. So to take the first, the effectiveness of the law, sex equality law traditionally was the strongest form of equality law or anti-discrimination law in the European Union. And the reason for that was that the prohibition against sex discrimination was contained in the treaties. And that was held by the court very early on to be directly effective. Now, what does directly effective mean? What that means in the European Union is that the law is part of domestic law, of national law of the member states, and it can be invoked by any person, any individual, before domestic tribunals or courts without needing to be adopted into domestic law by that state. So you can imagine that that makes the law much more powerful because states are not always inclined to adopt EU laws. It takes time to adopt legislation. They might change the law as they're enacting it into law, or they might just not do it at all if they don't like the law, and that often happens. Whereas if it's contained in the treaty has been there, it doesn't change very much from decade to decade, and individuals can directly invoke that law, which is a form of international law, I suppose, but as their domestic law in their domestic courts. So that's a very powerful tool.